On News and Information Station.
Welcome back. I'm Vince Perryman and you're watching Legalese. Joining us on our show is Laurie Hall and Bill Jones, local attorneys, and we are discussing alternatives to litigation in family law cases. Laurie, before the break we were talking about how if the collaborative law does not work out, then the parties have to hire new attorneys to handle the litigation. Well, and that to me seems like it might be an incentive to make sure things work out in the collaborative law realm. However, how does the collaborative process, how does it begin, and what are some things you, because I know sometimes with collaborative law process you actually go and you hire a mediator to help out. So if you can speak to those things.
Sure. Well, once the parties have retained their respective attorneys, then the parties and the attorneys get together and have a four-way meeting where first thing they do is sign the participation agreement that outlines what collaborative law is all about. It does contain a clause in there that if the parties are unable to resolve their issues and that they're forced to go to court, that they will have to retain new attorneys. Once that's been done and everyone has signed that agreement and made that commitment, then the parties can jump right in with their attorneys and discuss the issues. The issues have to be identified. They have to be fully discussed as part of the collaborative process. Each party has got to be committed to listening to the other side, to their partner, to hearing them out, and with respect. And then once everyone has had a chance to speak, then you work on resolution. Now, sometimes to help guide that process, the attorneys along with the parties will decide that it would be useful to bring in a mental health professional such as a counselor or a psychologist to help the parties along in that, especially when children are involved. I think that can be very helpful. If there are complicated financial issues, they'll hire some sort of financial planner or a financial expert to come in and assist the parties. And then, of course, there's mediation, in which a neutral is there to help guide them with their attorneys toward a resolution of issues. Okay,
and I guess that brings us to our mediation prong here on how the mediation process works. And Bill, if you'll talk some about that.
There's first there's a misconception in the legal community, and I think in the public, that mediation is something that always is done through attorneys, that attorneys go out and hire the mediator for you. There is nothing that would preclude, and certainly I would encourage parties that are close enough in an agreement to seek out a mediator first. You could sit down with a mediator, hash out the details, and then go to an attorney and have them draw up what you've mediated. But to answer your question, generally what we see is that either the court has ordered or a motion has been filed asking for mediation, or the attorneys have agreed to it because they think the case is well suited for it. The parties come in. There are two ways that we can run it. Generally, we can separate the parties where we do a room-to-room, where we go back and forth, or if the parties work well together, we can put everybody in the same room. Personally, I like to have everybody in the same room because I think it encourages some honesty and it encourages the parties to actually work together a little better, but sometimes that's not possible. As a mediator, your job really isn't to tell them I don't have a gavel. I'm not going to order this is what you're going to do. What I'm going to do is I'm not attached to the situation. I'm not personally invested. I'm not emotional about it. I can give the parties some alternatives that possibly they haven't thought of. Maybe I can tell somebody through my experience how I think a court would rule on their particular matter, and probably what's most beneficial is we do a cost-benefit analysis with the parties. If you settle today, this is where we stand. If you go forward, this is how much you're probably going to spend to go forward. And a lot of times when you do that, the parties can see that even if they were to go forward, with the money that they'd spend in attorneys and the time that it would take to get on the docket, a lot of times they'd be better off settling for a little less, because the cost-benefit analysis says they would spend whatever they would gain in a court setting litigating it. A lot of times, most every mediation I've been in has settled. Parties, when they get together, especially when there were kids involved, if they have the child's best interest in mind, generally they can come together and form an agreement. At the end of the day, we draw up a mediation agreement. Everybody signs it. Once it's signed, it is a binding agreement by all parties, and then the attorneys can go off and they can draw up the final paperwork.
Okay. Now, as far as in the agreement with mediation, that's a binding agreement. Now, with the collaborative law, that's also another binding agreement. So in those, I guess there's always a question of, what if you solve, 75% of the issues, but there's still 25% left? What happens then in both of these?
Well, in mediation, if you settle 75% of it, then again, from a cost-benefit analysis standard, we've settled 75% of the case. You're only going to have to pay your attorney for 25% of the case. So it's still a windfall to you.
Okay. And in collaborative law?
From the collaborative law perspective, the case must settle on all issues with the attorneys that have been retained to engage with the parties through the collaborative process. If the parties are able to resolve most issues but not all, then and they do choose to litigate the remaining issue, then they have to do so without their collaborative attorneys.
Okay. When we return from our break, we will talk more with Laurie and Bill about alternatives to litigation in family law cases. Please stay with us.